I don't understand why you're smiling.
I took a calabash and hit her once on her head.
Of an entire family.
What is the best place to stab someone?
A murder has shattered a family in Soweto, leaving them searching for answers. They are struggling to cope with the brutal way their 62-year-old grandmother was killed. This tragedy unfolded after her own granddaughter, 33-year-old Nomaswazi Tshabalala, admitted to the crime in court. She recounted how, during a fierce argument in 2019, she killed and buried her grandmother in their backyard. Now, she faces her family as a cold-blooded killer, confronting the pain she caused.
Struggling a lot with this. It's hard to accept, it's hard to process, but I hope at the end of the day we'll be able to find closure and move on with our lives.
In court, the 33-year-old finally spoke up.
On the charge of murder, how do you plead?
It was not my intention, my lord.
So you plead not guilty?
No.
Guilty, my lord.
In a plea deal, Nomaswazi Tshabalala disclosed how she killed her grandmother during a heated argument that seemed to be fueled by drugs.
After smoking, I went back to the house and I found the deceased already picking out my things and placing them in the kitchen. She continued yelling at me and we ended up engaging in a fight. I took a calabash and hit her once on her head and she collapsed. Paragraph 4, I became so frustrated in that I didn't know what to do. I went to my bedroom and I smoked again. After smoking, I went back to her bedroom, in brackets, the deceased, and I find her snoring. I then suffocated her with both my hands until she was emotionless.
Nomaswazi Tshabalala also admitted to stealing her grandmother's bank and social security cards, withdrawing over 15,000 grand from her accounts.
I think we will find closure as a family knowing that the person is sentenced accordingly to the crimes she committed. I'm not someone who is heartless, but when it comes to a situation in jail, I don't think I'll be able to forgive her.
Tshabalala sat with her face down, appearing to cry as the horrific details of how she killed her grandmother were read in court. The 33-year-old has been found guilty of premeditated murder, and the state plans to seek the harshest penalty of life in prison. A judge delivered strong words during the sentencing of a man who killed his estranged wife in front of their daughter.
Mr. Lynch, you're going to go to prison for basically as long as I can send you.
Joshua Lynch will spend the rest of his life in prison. The judge announced this sentence a week after finding him guilty of several serious charges, including murder. Cuyahoga. Judge David wasn't the only one who believed convicted killer Joshua Lynch deserved a tough sentence for killing Jovan Ferguson Lynch. Her family members were also present in court, explaining to the judge why he should face life behind bars.
This has affected us beyond, I can't even put it in words. He took a mother from a daughter from a mother, a sister from a sister, and an aunt from her nieces and nephews. He took her from us. He took my baby sister from us. And my niece don't have a mom. Nor does she have a.
Then her mother spoke, the one raising Jovan's daughter, the girl who witnessed her father kill her mother.
My daughter ain't gonna never see her mother again. I got custody of her. I can't take the place of her. I can't do it.
They requested the maximum sentence for 36-year-old Joshua Lynch, and the judge agreed.
Mr. Lynch, if there was ever an individual who doesn't deserve to walk free amongst organized society, it's you.
The judge convicted Lynch of 2 counts of murder and several other charges, including gross abuse of a corpse after a bench trial. He sentenced him to 28.5 years to life. The judge highlighted that Lynch shot Jovan twice in February 2023, while their daughter was in their Cleveland home.
Is this fun for you?
Lynch smirked as he heard his sentence.
I don't understand why you're smiling.
He was on the streets and able to kill Jovan despite having a dozen prior felony convictions. After the hearing concluded, Jovan's family celebrated. Her Her family shared that the sentence means little to them. It doesn't bring Jovan back. Joshua Lynch chose not to make a statement during his hearing or explain why he laughed and smiled while being sentenced to life in prison. A Buffalo woman was visibly upset upon learning her fate. A judge sentenced Lashawn Lewis to 25 years to life in prison for murdering her mother 13 years ago. Lewis received the maximum sentence for stabbing her mother to death in 2005, a crime she insists she did not commit.
She was my best friend. She was my strength. There's no way on earth that I could have taken her life.
A jury saw it differently. Lewis was convicted of second-degree murder during a retrial following a hung jury in July. She was arrested after cold case investigators linked new evidence to the case.
The problem was that it was all circumstantial evidence. It was a tough case, and my office, I was willing to take a tough case on.
The allegations that Lashawn Lewis her mother, Latifah Lewis, 40 times at their home on Orange Street created a rift within her family during her arraignment. The tension remained high in the courtroom during Lewis's sentencing.
You lied.
Lewis frequently interrupted a family friend who was delivering a victim impact statement.
She got her GED, she went and got her job, she made her life the best she could, and she was at a point in her life where she felt that it was time for her to enjoy her life.
You didn't even know my mother. How could you say these things?
State Supreme Court Justice Christopher Burns stated that the jury reached a fair verdict in this case and sentenced Lewis to 25 years to life. She spat into the gallery as she was led out of the courtroom. Latifah Lewis's family and friends weren't surprised by Lashawn Lewis's behavior, describing her as a nasty person. Her daughter-in-law mentioned that after 13 years, the sentencing provides some closure.
A little bit, but I wish I had my mother back.
Lewis has 30 days to appeal her sentence, but the district attorney expressed confidence that the right person will be imprisoned for this crime. He stated that he hoped she would spend the rest of her life behind bars. There was chaos in the courtroom when a 75-year-old killer verbally attacked the wife of the man he murdered. This outburst occurred just before the shooter found out how many years he would spend in prison for killing a man over a dispute. That's why I killed him. He cried like a baby. Those are the words Omar Rodriguez shouted at the wife of Jose Ray, the neighbor he shot and killed because of his dog.
Was your husband. You pathetic coward was your husband.
Stability and safety of an entire family.
That's why I killed you. Check him out, Josh.
Rodriguez had a reputation for being aggressive and difficult among his lifelong neighbors in Kendall.
The guy we saw in there yelling, is that the neighbor that you...
That's exactly who he is.
Yeah, that's exactly his behavior, and we were not expecting anything less.
Jurors convicted the 75-year-old in May for fatally shooting Ray. He was hoping for a lighter sentence from the judge, but Rodriguez was sentenced to life in prison.
And he is sentenced to life with a 25-year mandatory minimum term.
Ray's wife is relieved that he won't get out, but she wants a longer sentence.
I wish, though, that the death sentence would have been on the table, because at the end of the day, Mr. Rodriguez will continue to see his family. They'll be able to visit him and see him. I'll never get to see my husband again.
Regarding Rodriguez's attack on her, while she spoke about her loving husband, Lizette says she is unbothered.
I wasn't listening to exactly what he was saying. I was tuning him out. I was just reading my thoughts. His words are irrelevant. He is irrelevant in my life right now. He is pond scum.
Rodriguez's attorney was left speechless by his client's behavior. The 75-year-old was removed from the courtroom before hearing that he would spend the rest of his life in prison. In a released jail call, the killer stated that if he had to do it all over again, he would do it the same way. The jury recommended 25 years in prison for the mother due to the murder of her own son, Kitten Brown. A judge finalized that sentence for Mollie Shouse. While the decision didn't surprise some, the raw emotions from the prosecutor did. Attorney Erin McKenzie, known for her tough demeanor in the Commonwealth Attorney's Office, admitted that this case has taken a toll on her. As the case came to a close today after nearly a year, she couldn't hold back her emotions and expressed her exhaustion.
Kitten Brown cannot give you a victim impact statement. And there is nobody here in this courtroom from his family to give you a victim impact statement.
His mother, Mollie Shouse, has been convicted of his murder. His father, Kenneth Brown, is in jail for murder in an unrelated case. Assistant Commonwealth Attorney Mackenzie didn't hold back as she served as his advocate.
It falls on me to remind the court of the life that was lost, of the little boy who will never have his first day of school.
After more than a year filled with graphic and disturbing details about the boy's death, Mackenzie's emotions reached their peak.
The little boy that sat in his car seat and suffered for hours upon hours, while his skin against the hot plastic of the buckle between his legs, with his little wet diaper stuck to him in the heat. There's nobody here to speak for Kenton today.
The final sentencing was up to Judge Stephon, who agreed with the jury's recommendation of 35 years.
Ms. Shouse, you chose the drugs over the life of your child. And so the court will sentence you today.
With no visible emotions, Shouse was led to prison, an outcome that brought the prosecutor to tears.
Just needed to see that for myself, to have peace with this case.
Judge Stephon also admonished Mollie Shouse, stating that she showed remorse only for herself, not for the boy she was convicted of murdering. Her defense attorney attempted to reduce the 35-year sentence to 20 years, and Shouse's mother even spoke on her behalf. However, that request was denied, and she was immediately imprisoned. A Marion County man, Michael Jones, admitted to killing his family and was sentenced for their murder.
Top of the show, sentencing had begun for the Marion County man who admitted to killing his family. We now know he'll face the death penalty. Michael Jones pleaded guilty to killing his wife and 4 children in 2019. A judge gave him a life sentence for the death of his wife, but gave him the death penalty for the 4 children.
A judge handed down a life sentence for the death of his wife, but imposed the death penalty for the murders of the 4 children. On March 6, 2013, Stephon Roby killed his mother and younger sister in Saginaw and was subsequently convicted. The jury carefully examined the details of the case before delivering their verdict.
Each count, the title of each count, and what your verdict is.
Count number 1, first degree premeditated murder of Charlotte Anessa King. Guilty of first degree premeditated murder of Charlotte Anessa King. Count number 2, possession of firearm at time of commission or attempted commission of felony. Felony firearm, first degree premeditated murder, count 1. Guilty of first degree premeditated murder of Lee Andrea King. Guilty of first degree premeditated murder of Lee Andrea King. Count number 4, felony firearm, first degree premeditated murder, count 3. Guilty. Firearm, a felony firearm, first degree premeditated murder. Count number 5, felony possession.
Responsible for the deaths of 2 of the most vulnerable, non-threatening people in his life, his mother and his sister. And nothing was injured during his trial in his defense that led our family to believe otherwise. But in spite of this terrible crime, his mother would still want him to receive the mental health treatment that he so adamantly rejected in the past.
And I feel as though that most of my emotions didn't get back because you were distracted.
Well, that is totally untrue.
Well, when she was on the stand, your phone kept on a couple times, and you kept asking her, was it her phone? When I came into the courtroom, I seen you on the phone.
Not while the court was in session.
Okay, but your phone was still going off and you were still distracted by the phone.
No, that is untrue. That is totally untrue. And that has nothing to do with the sentence.
Yes, it does have something to do with it.
Do you have anything you want to tell me in regards to this sentence?
Yes, I want to vote for mistrial because I don't...
Denied. Anything else?
No.
This is one of the most egregious cases I've ever had. When you... Your mother,
don't worry about what I...
The woman that brought you into this world, and your sister. And you're going to spend the rest of your natural life in prison. Hopefully someday you'll think about that. Get him out of here. I'm done.
He was sentenced to life without the possibility of parole. Life in prison without the possibility of parole is the sentence a serial killer received for 2 murders in St. Louis County. In the St. Louis County Circuit Courtroom, Tyler Terry pleaded guilty to murdering 71-year-old Barbara Goodkin and 58-year-old Sergei Zakharev on May 15, 2021, a date that changed many lives forever.
Pursuant to negotiations with 4 different counties, 2 in South Carolina, as well as Nashville, in an agreement pursuant with those other jurisdictions, the court sentenced Terry to life in prison without possibility of parole and multiple life sentences, all to be run consecutively.
Surrounded by members of the major case squad, St. Louis County prosecuting attorney Wesley Bell thanked the district attorneys from Chester County, South Carolina, and Tennessee for their assistance. Inside the courtroom, Stanley Goodkin, the widower of Barbara Goodkin, told Terry, "You are a worthless piece of crap and should be sentenced to a slow, burning, torturous death." Alex Zakharev, the brother of Sergei Zakharev, expressed that Sergei was a doctor who saved lives every day, adding, "I'm glad you're going to die in prison."
This heinous crime gripped the St. Louis metropolitan area, that people were just coming home from dinner and they were assaulted over on Delmar Boulevard. And Dr. Zakharev, he was just getting off an airplane coming back from Florida and was just minding his business.
Retired Olivet Police Chief Rick Knox credited the multi-jurisdictional efforts that led to the capture of Tyler Terry and Adrian Simpson. Simpson has been charged as an accomplice, and Knox stated he expects progress in her court case proceedings within the next month. A boy accused of murdering his mother appeared back in court. For the first time, his confession to detectives was revealed in court.
I grabbed one of the kitchen knives and then I went to our room and then it's okay, you can say
The court played a chilling interrogation video showing Derrick Rose allegedly confessing to the of his mother, Irina Garcia. In the video, Rose admitted he had considered killing himself afterward, but ultimately changed his mind. Family members in the gallery were left sobbing as they listened to the heartbreaking confession. Surveillance stills released by the state attorney's office show what appears to be the teen, Derrick Rose, standing over his mother's bed while gripping a knife.
Did you tell her anything before you in Spanish?
Were there wounds to her face?
The homicide detective in this case described not only the 46 inflicted on the victim, but also detailed Derrick Rose's reported actions leading up to the brutal crime.
Yes, on October 12 at 6 p.m., he did make searches on Google. Okay. He typed in the word, the carotid artery image diagram. What is the best place to stab someone? Is a small knife good for killing?
This hearing is being held to determine whether Derrick Rose should be held as a juvenile while he awaits trial. A corrections corporal testified that due to Rose being a high-profile inmate, he is kept alone in his cell and supervised 24 hours a day. A psychologist noted that Rose has ADHD and that another doctor tested him for being on the autism spectrum. Additionally, it was revealed that Rose was suicidal when he was first brought in. David Temple, a former high school football coach, has been twice convicted of killing his pregnant wife in Katy. However, he has been waiting for over 4 years for sentencing. Grace White reports that his fate is now in the hands of a new jury. Jury selection began to determine Temple's sentence. Since his wife's murder occurred in 1999, he faces a range of possible outcomes, from probation to life in prison. However, due to sentencing laws at the time, he could eventually be eligible for parole, as there was no life without parole option back then.
This day's about Belinda. This has nothing to do with David Temple.
That was Brian Lucas speaking after the second trial in 2019, which took place 10 years after his sister, Belinda Temple, was found in the closet of her Katy home. At the time of her murder, she was 8 months pregnant.
Guilty of murder as charged.
A jury twice convicted her husband, a football coach, of the murder. Prosecutors revealed that he was having an affair at the time of the killing and later married his mistress. However, she filed for divorce as the second murder trial began.
You see this on TV and you think, oh, this would never happen to you. Well, till you go through it, you don't know what it's like.
David Temple's first conviction was overturned due to prosecutorial misconduct. Although he was convicted again in a second trial, the jury could not agree on his sentence.
10 jurors in the retrial wanted life. For whatever reason, 2 jurors held out. And that brings us to where we are right now.
Andy Kahn, who has supported the family since the beginning, stated that they have faced numerous delays in the case, further exacerbated by the pandemic.
Interesting to see how the state presents a case in a sped-up fashion to a jury to get them up to speed, and they ultimately will determine the sentencing on David Temple.
David Temple's attorney has declined to comment ahead of the trial. Jury selection will continue tomorrow, and the sentencing phase will begin shortly after. The case revolves around Matheu Moore. On May 25, 2020, in Westerville, Moore's wife, Emily Noble, disappeared. A few months later, her body was discovered. Just over a year after her disappearance, Moore was arrested for her murder. After considering every aspect of the case and investigation, the jury decided. The judge would soon deliver the verdict.
The court will now announce the verdicts. Verdict on count 1. We, the jury, being duly impaneled and sworn, find the defendant, Matheu L. Moore, not guilty of as he stands charged in count 1 of the indictment, dated the 26th of August, 2022, signed by all 12 members of the panel. Verdict on count 2. We, the jury, being duly impaneled and sworn, find the defendant, Matheu L. Moore, not guilty of as he stands charged in count 2 of the indictment, dated 26 August 2022, and signed in ink by all 12 members of the panel. Verdict on count 3. We, the jury, being duly impaneled and sworn, find the defendant Matheu Moore not guilty of felonious assault as he stands charged in count 3 of the indictment, dated August 26, 2022, signed by all 12 members of the panel. Ladies and gentlemen, I cannot personally enough express my appreciation for the time and the attention you have given to this court during the course of this trial. This is one of the longer trials that occur, and you all were willing to give your time and absolute attention to this matter, and you certainly received the thanks not only of this court but the community as well for your service. As I said earlier, and I believe it again, your participation has strengthened and fully served our institution of justice in this county and everywhere else, for that matter. So we have now concluded your service to the court in this matter. I will, now I guess number one, I'm going to share with you, you are released from your admonition. So now you may speak to anyone that you wish about this matter. You may review anything that's been going on. It's entirely your prerogative. I will now discharge you, and you can go back to the jury room. I will tell you that I would like to go back and speak to you privately if you're willing to do that. In other words, if you wish to leave, you're certainly entitled to do that. If you'd like to go back when I concluded my business here, I'll briefly go back and speak to you, share some moments with you, and then certainly you can go on your way. So it's up to you, but I'll have you go back to your jury room now, and we'll proceed with a few things in here, and I'll be back there shortly. Thank you. Mr. Moore, I think from day one, everyone's wanted justice for your wife, Emily. And I've heard that phrase a lot, and I think everyone truly desires that. But I think the jury has also said justice for Emily is not injustice for you, and they have reaffirmed that. I will just formally say I am terminating the bond previously set in this case, and you will be discharged and you are free to go. We will do that, and we have an entry that will prepare immediately to cause that to happen. All right? Anything else from the state?
No, Your Honor, thank you.
Anything else from counsel?
No, Your Honor.
I'm going to ask them if they would be willing to speak to counsel. That's really one of the main things I'm going to be doing. So if any of you would like to do that, I will come back out here and let them know, and then you can go speak to them if you wish. Thank you for your service in this case. You did a fine job, and same with you folks. So we are in recess. We will file the verdicts with the clerk. We'll proceed from there. Thank you.
The case centers on Billy Ray Turner. In 2010, Turner ended the life of former NBA star Lorenzen Wright. He was arrested and charged with Wright's murder in 2017. In court, Wright's mother shared her profound grief and the emotional wounds inflicted by her son's tragic death.
Well, y'all, he was my firstborn child. I told my other kids they need to use him. I used him as an example. Whatever milk didn't work for him, I didn't give it to the other. Whatever pamper didn't work for him, I didn't put him on the other one. He was just the example kid for them. And I used to tell all the time that they got to thank him because a lot of stuff y'all didn't have to go through because he made sure y'all didn't. Let's fast forward to this little boy. He was born a big boy. I'm talking about he was like, I couldn't even hold him like this without holding his head. He was that long. Only back I could hold him like that was his granddad and his dad because they had those long legs. And this boy, for some reason, he never crawled on hands and knees. Both his hands and knees never touched the floor. He crawled on a tiptoe and a hand like this. Not, my mom's called him Mr. Big Stuff because he would never let both his hands touch the ground. And he went from that position to walking at 9 months. He was just something totally, had nobody been in our house in 10 years. And that was my brother. So he was just excited. Everything he did was exciting because we hadn't seen nothing like this anyway in a child this big. Then when he started walking and talking, Lord have mercy. He was a big boy then. Fast forward to 6 years old. I used to have to take his birth certificate to the movie with me to prove that he's 6. Because he was just that big. I carried that.
They were trying to charge you for adults?
Yes, they were. It was so messed up until I got a copy, matter of fact, right now, that he sending me to keep because the one I had was so folded and crispy. It was like ugly now because I carried it for the years from place to place. And then he started playing basketball, real basketball. He was serious even then. I was like, okay. Then getting in his pre-teens, he would go to the activity center in my town, and all the other guys, grown men, girl, you know you got a ticket right there. That boy gonna make you some money. I'm like, I don't want y'all to blow his head up. Shut up. You know, he young. Don't let him think this. But as time went on, I went to seeing it myself. Oh my God. What is at home, no sitting room. Because everybody want to see what Red gonna do tonight. And then we got the Oxford and Lorenzen went to the Fed, and we got Oxford. That's our route for school. I bet at every game we was gonna win. I could get the players to come to court right now, tell you how many fifties I got. They paid me because we won. Because of my son. Like let me tell you what happened here in Memphis. Y'all, I'm hurry up. The guy had knocked Lorenzen down. I'm sitting behind the coach when he telling him to throw a roadblock, but I had no idea he was talking about on my son. 20 minutes later, my son hits the floor. He gets up, want to hit somebody. Then they push him out the game. He goes to the wall, talking, he's not going back here. Oh, yes, he is. His dad talked to him and his coach talked. His dad said, I said, boy, I flew over there. If you leave the game, you're going to mess your whole team up because ain't no I in team. You got to stay in the game. And we won. Next game, we had to have a police escort in the game because they going to kill him. Over basketball in high school. I'm not talking about college yet. This is just straight high school. He was just different. I had girlfriends that had nephews and brothers playing on team, but they would come to the games with me so they could be his cheerleaders. Because they saw something that nobody see too. Because look at his stats. He just did too well, to be like example. I'm going to start giving y'all examples of the people. He was in the 8th grade and we went to state. If they knew about him being in the 8th grade, they would have took the trophy from us because he wasn't supposed to be playing with no high school. But we needed him to win. And that's what we did. The Fed High School. I wish y'all could just go look at see what all kinds of trophies he got for them because every trophy they got, he's on it. It might be just a little inscription under the school, but he's on there. Oh, I'm finna jump way up somewhere now.
You have a lot of stories going.
That's why I suffer it don't weigh so much, because I can sit here all day and talk about him. All day. Okay, he gets married. Had me some grandkids. Y'all, my first grandchild was so spoiled, I couldn't let Loretta touch him, because he was like, oh, I told him his poop don't even stink, so move. That firstborn was firstborn, literally. Everybody, all my friends, everybody know who was my heart. That was Snoop. Firstborn grandchild, he didn't do no wrong in my eyes. I always saw a better way out for him. And then what really got me disgusted about him really getting murdered is called 6. 6 in 1. 6 kids and 1 mom. And my baby grandson been talking about playing basketball all his life. When this happened to his dad, he didn't play no basketball. He said, I just asked him why. Well, let him just go on and do what he do. And he was like, well, Grandmama, I don't want all the focus on me like it was on my dad. He's the younger brother, and he's tall as the twins. So he would have been a good prospect for the NBA. But he said, no, all this stuff, it changed his total life with my son not being. He didn't have anyone to guide him in no direction. And Laura said, well, maybe Grandma, he just didn't want to play. I said, you mustn't see the Venus and Serena stuff. They didn't either. But they did. I said, what? Back out there. Sometimes you need your parents in your life to, stay on you. You got to do this. They're children. You got to put some on their mind. You can't just let them do what they want to do. Even, if my son had been here long and said, Dad, I'm not playing ball, he will write me an essay. Why? Because I don't want to. That's not good enough. You got to have a valid make it make sense. You got to have a valid reason for not doing what I think you can do better than average.
So those grandkids lost a father.
Ooh, they lost a lot. Those kids had love all day, every day from their dad.
State is also asking the court to consider whether or not the defendant is a dangerous offender whose behavior indicates little or no regard for human life and had no hesitation in committing a crime in which the risk to human life was high. And again, for enhancement purposes, that if it's implicit to the crime itself, the court cannot consider that for enhancement purposes. But for consecutive sentencing purposes, those are separate things that the court, in fact, can consider separately if it, in fact, raised or proved by the proof in this case or at the sentencing hearing. Mr. Billy Ray Turner had absolutely no hesitation in committing a crime in which the risk to human life is high. Chased Mr. Lorenzen Wright through a wooded area, went to Atlanta, and it has nothing to do with the risk of life being high to an unnamed or an unindicted victim, but the totality of the conduct for which he has in fact been convicted by a jury. Went to Atlanta, to Lorenzen Wright, was not successful, conspired for a number of time, weeks, at the behest of Shara Wright to Lorenzen Wright. Asked Shara Wright at one point, tell me, Shara, what do you want me to do? Located him, found him, got a text that says he's here, party's on, or something to that effect. Found him, chased him. As Lorenzen Wright is hopping fences, jumping fences, running through a wooded area, literally running for his life. So Billy Ray Turner unloaded a on him, a 9mm pistol on him multiple times. The circumstances surrounding the commission of this offense are in fact aggravated. Court also has to find whether or not the aggregate length of the sentences reasonably relate to the severity of the offense for which the defendant stands convicted and are necessary to protect the public from further criminal acts by the defendant. Not further criminal acts of violence, but just further criminal acts. And that's State versus Wilkerson, Wilkerson, 905 Southwest 2nd, page 933, 1995 Supreme Court opinion, Tennessee Supreme Court opinion. Those are known as the Wilkerson factors, and the court does again find that not only is Mr. Turner a dangerous offender, because that's a chase a person with a travel out of state with intent to kill somebody, hatch this nefarious plan to kill this man, comes back to Tennessee, where he's set up by Shara Wright, notified as to where he is, finds him, chases him, with a 25-year history of committing crimes against the state of Tennessee, including kidnapping, aggravated drug offenses, the three worst combinations that you can think of: guns, drugs, violent offenses. Mr. Billy Ray Turner checked all three of those boxes. He is a dangerous offender. He had no hesitation committing this crime, and he has shown over the totality of his adult life that he will continue to commit crimes against the state of Tennessee. I'm ordering that the life sentence that was imposed at the conviction in this case be ordered to be served consecutively to the convicted felon in possession of a firearm, the 16-year sentence that the court imposed on or about June 17, 2019, 1801702. I'm going to order that the two 25-year sentences on this case be served concurrently with one another. I could actually impose those sentences consecutively. Also, the state is recommending concurrent sentences, and that's non-binding on the court. The court could actually order consecutive sentences, but I would not order consecutive sentences on the conspiracy and the attempted 25-year sentences. Those sentences will be served concurrently with each other, but that 25-year sentence will be served consecutively to count one of this indictment. The life sentence will be served consecutively to the convicted felon unlawfully possessing a firearm. Total effective sentence of life plus 41 years confinement in the Tennessee Department of Correction. Will not impose a fine on these cases. The court does render Mr. Billy Ray Turner infamous on these convictions for which the jury has returned his verdict of guilt. Will give him all the jail credit that he's been in custody towards the release eligibility. I understand that Mr. Turner will, in fact, appeal these convictions. And I wish him good luck on appeal. We'll hear his motion for new trial in 30 days or less. And if Mr. Turner prevails upon the court and says, Judge Coffey, this is why you should grant me a new trial, I would certainly listen to any arguments that Mr. Turner makes at that motion for new trial. Life in Tennessee, what does life in Tennessee mean right now? I have no idea what life means. Every time the legislature goes back into session, there's a movement that says we need to look at what life means in Tennessee. We need to reform sentences, because if you sentence a person to life, that person has to serve 51 years in prison before he can be released. As Mr. Perry argument, that really doesn't incentivize, give a person encouragement to say, let me do well and maybe I can get out of prison before 51 years. I have no idea what 51 years mean. Would next year the legislature go out in session and say we're going to have folks become eligible for release after serving 25 years of a life sentence or 15 years of a life sentence? Because you keep hearing that Tennessee's life equals 60 years may be one of the longest sentences in this country. So I have no idea what life means. Does Mr. Turner have to serve 51 years of sentence? I don't know. We'll find out next year. We'll find out in 5 years. We'll find out in 10 years. But it would be irresponsible of this court to tell a person who has 9 on that record, 10, 11, now 12 felony convictions on his record, 12 felony convictions over 25 years, that we're going to order all of these sentences to be served concurrently. It is not in the best interest of justice. It is not in the best interest of deterring crimes. If consecutive sentences are not warranted on this case, the state of Tennessee, the legislature needs to do away with consecutive sentences. Mr. Turner has earned every day, every second of this life plus 41-year sentence, with no exception for the record. And we need a date for a motion for new trial hearing. It has to be held within 30 days, 4 weeks from the day.
On April 3rd, 2023, in Ohio, teenager Brandon Morissette brought a firearm to school with the intention of attacking another student. This incident has caused widespread concern in the city, particularly among parents. Now, it's up to the press and law enforcement to restore calm and reassurance.
The school resource officer and administrators began the immediate process of interviewing each student that accessed the restroom. One of the students, identified as Brandon Michael Morissette, was interviewed at approximately 9 a.m. and his book bag was subsequently searched. Located inside of the bag was a handgun and 3 loaded magazines. Mr. Morissette was immediately arrested, handcuffed, and searched. The search of Mr. Morissette revealed that he also had a lock blade style knife secured to the exterior of his pants. West Geauga administration immediately placed the high school on a shelter-in-place status, which was disseminated to all students and faculty. Mr. Morissette was then transported to the Chester Township Police Department, where he was interviewed by detectives. Information obtained by law enforcement and school officials determined that there was no additional threat to the high school, nor was there a threat to any other buildings in the district. In an abundance of caution, additional law enforcement resources were requested from the Russell Township Police Department and the Geauga County Sheriff's Office. With a large police presence established, all students at the high school were released for the remainder of the day. Law enforcement then conducted a thorough sweep of the interior and exterior of the high school to include an explosives detection canine from the Geauga County Sheriff's Office. During our interview with Mr. Morissette, he admitted to using prior calculation and design in developing a plan to cause harm to students at West Geauga High School on April 3rd. He further acknowledged that the firearm seized by law enforcement on Monday was the weapon he intended to use to inflict that harm. The Chester Township Police Department's Detective Bureau, with the assistance of the Geauga County Sheriff's Office, conducted a search warrant in Mr. Morissette's home in Lyndhurst, Ohio on April 3rd. Numerous items of evidentiary value were secured at that time. The investigation into this incident is ongoing. On Tuesday, April 4th, the Chester Township Police Department charged Brandon Michael Morissette with attempted aggravated murder, a felony of the first degree, illegal possession of a deadly weapon in a school safety zone, felony of the 5th degree, and inducing panic, a misdemeanor of the 1st degree. He's currently being held in a secure mental health facility, and upon release will immediately be transferred to the Geauga County Safety Center. The decisions made by administrators and faculty on the morning of April 3rd were appropriate and direct, and I have no hesitation in saying that those decisions saved the lives of students and faculty. Dr. Markward, Principal Patty, Assistant Principal Puskis, and countless other faculty members of West Geauga schools should be proud of their efforts and, most importantly, the outcome. No students or faculty were injured. I would first like to thank the alert student that brought this to the attention of law enforcement. I would also like to thank our officers and detectives for their tireless work ethic throughout this investigation and for the care and empathy that they have exhibited. Additionally, I must thank the Russell Township Police Department, Geauga County Sheriff's Office, and the Geauga County Prosecutor's Office for their assistance and collaboration throughout this investigation. We are fortunate to have such a professional and selfless group of law enforcement professionals in this county. Thank you.
Mr. Burling, will you introduce the case, please?
Yes, Your Honor, thank you. This case was indicted on May 2nd of 2023. It is a 3-count indictment charging Mr. Morissette with attempted aggravated murder, a felony of the 1st degree. That count carries with it 3 specifications. The first specification alleges that the defendant committed the offense of attempted aggravated murder while in a school safety zone. The second specification alleges that Mr. Morissette had a firearm on or about his person or under his control while committing the offense. And the third specification seeks forfeiture of the firearm alleged to be used in that count. Count 2 is illegal possession of a deadly weapon in a school safety zone, a felony of the 5th degree. And count 3 is inducing panic, also a felony of the 5th degree. We are set today for initial appearance and possible arraignment. And Your Honor, I know this case did originate in Charter Municipal Court. However, I believe this was a indictment prior to the scheduled combined over hearing. So today, as mentioned, is the initial appearance and possible arraignment.
All right, thank you. Mr. Hilo, on behalf of your client, do you waive any irregularities as to time and place of service of the indictment?
I do, Your Honor.
Do you all?
For the record, Your Honor, we waive any defects in form of service of the indictment. Waive reading of the indictment, and would enter a plea not guilty members of this hearing.
All right. All right, Mr. Morissette, your attorney has indicated that you're waiving a formal reading of the indictment, so I'm not going to read the indictment to you word for word. I do want to go over the maximum possible penalties with you. Count 1, attempted aggravated murder, a first-degree felony with specifications. As far as the first-degree felony, that could carry with it a possible prison sentence of 3 to a maximum of 11 years definite, plus an additional 5.5 years indefinite, for a total possible maximum term of 16.5 years. As to the first specification to count 1, that is the offense of violence, that the allegation of offensive violence in a school safety zone, that could carry with it, if convicted on that specification, an additional 2 years that would be required to be served consecutive to and prior to any other prison sentence. As to the second specification, that would require a 1-year mandatory additional consecutive and prior if convicted as to that specification. And then as to the third specification, if convicted, that would require the forfeiture of the Smith & Wesson Model 910 alleged to be involved in this matter. As to count 2, illegal possession of a deadly weapon in a school safety zone, that's a 5th-degree felony. If convicted, that could carry with it a possible prison sentence of 6 to a maximum of 12 months and a maximum possible fine of $2,500. Also, since you're under the age of 19, there would be a mandatory Class 4 driver's license suspension, which would be for 1 to 5 years. As to count 3, inducing panic, that's a 5th-degree felony. If convicted, that could carry with it a possible prison sentence of 6 to a maximum of 12 months and a maximum possible fine of $2,500. Mr. Morissette, do you understand those maximum possible penalties?
Yes.
All right. Mr. Burling.
I may have missed it, but I wasn't sure if you said on count 1 that potential fine of $20,000.
I think I did forget that. Thank you. There would also be, as to count 1, a potential fine of up to $20,000. All right. Now, I'm going to go over your constitutional rights with you. You have the right to counsel. You have the right for a reasonable continuance to obtain counsel. If you cannot afford counsel, counsel will be provided for you at the state's expense. You also have the right to remain silent, the right to a jury trial, and the right to reasonable bail. Do you understand those rights?
Yes.
All right. All right, and Mr. Hilo has filed a notice of appearance in this case. Also, I will acknowledge, and Mr. Hilo mentioned it, that the court is aware that Mr. Hilo, on behalf of Mr. Morissette, has filed a written plea of not guilty by reason of insanity. The court will order an evaluation.
Sorry if I stumbled through.
That's okay. Take your time.
My son is a loving, respectful young man. All of his emotions and bottled them inside for over a period of years. In order to help me and his mother. His mother was diagnosed with terminal cancer in 2019. At the time, we tried to keep how bad the cancer was from him. He still had the support of his friends and family until 2020 when COVID hit. I was one of the lucky ones who still was able to work in healthcare, but that meant I had to quarantine every day after work due to her condition. This left Brandon to take care of his mother the best he could, with me shouting instructions through the basement door. Brandon became isolated from his friends and family. Once some of the COVID regulations started to lift, his mother started to decline faster. Brandon watched his mother pass away slowly from home. He then turned to me to help me with my grief, never once asking for my help. When I visited him at the hospital after the incident, he greeted me with open arms, which were covered with over 50 knife wounds from him trying to bury his pain. When I asked him why he did what he did, he responded with, "I don't want to die in the same house as Mom." nor for you to find my body. I still believe the reason he left that bullet in the bathroom was for someone to call the police and he get died by suicide by cop. This is not an excuse for his actions, but meant for the court to understand that he's a loving and respectful young man who still has hopes and dreams that have a positive impact on society. Thank you.
I would like to start off by saying that I am truly and sincerely sorry for my actions. I did not mean to scare you all, and I am sorry for that. I also did not intend to cause any harm to anyone whatsoever. I only had the intention of harming myself. However, I do take full responsibility in my actions. And what I did was not right at all. At the time, I wasn't right mentally, and I was going through a lot. I was still having trouble processing my mother's death from cancer in 2020. I have always had mental health issues when it comes to depression and anxiety. I was bullied when I was in middle school, and I've always had self-esteem issues. Many times I've thought about suicide, and some of those times I've tried. I'm not telling you these issues about my life to make excuses, but in the hopes that you can know me better and why I felt the way I did. In no way, shape, or form am I the same person as I was before. I am now doing everything in my power to be a different person. I am taking classes like RU and Climb to better my mental health. I would like to continue to better my mental health when I am in the real world. I do not want to go back to the old person I was. I want to better myself and accomplish my goals. Have a family, hopefully maybe join the military. I am not a bad person. All my life, I've been good. I've never gotten into trouble with the law or have gotten into any fight. I am a kind and helpful person and truly care for others. I just wish you were all able to know me as a better person and not the one I was during the dark time I went through. Please have mercy on me and please forgive me for what I've done. I promise if you give me a second chance, I will do whatever it takes to turn my life around. Thank you for your time.
So taking all of those into account, as well as the other things that we've taken into account, Mr. Morissette, I heard your statement that you made here in court today, and I read the statement that you submitted to the court prior to today's hearing. I read the letter of support from your dad, and I heard what your dad had to say here today, as well as your attorney. I understand that you were depressed, and I understand that you were in a horrible place after losing your mom. I'm not unsympathetic to the situation you were in, and I believe and understand that you were in a really bad place. But we did have, as Mr. Flays pointed out, 2 evaluations from 2 psychologists who said that you knew the wrongfulness of your actions. This was not a snap, spur-of-the-moment decision. The evidence demonstrates that you had a plan. You've pled guilty to attempted murder. Mr. Flays referenced the videos on your phone, both the ones that you made and the ones that you watched. You also packed a gun and 3 fully loaded magazines in your backpack and took them to school with you. And regardless of whether we believe the version that you were going to just hurt yourself or whether we believe the version that you planned a shooting, it's clear that you did have the intent to use that gun in the school. Once again, based on what was found in the videos on your phone, based on the fact that you took 3 fully loaded magazines, the evidence does show that you planned to carry out a school shooting. You may have wavered back and forth, but at least that was a plan. Now, we know that no one was physically hurt. by your actions that day. But we can't say that nobody was hurt. The entire community was terrorized. When that shelter in place occurred, it was terrifying for the students. It was terrifying for the faculty and staff. It was terrifying for their parents and families. And some of the responding officers that responded that day were some of the same ones that had to respond to Chardon High School. You can't say no harm was done to them. Your conduct in establishing this plan and taking action to carry it out has to be taken seriously, and the sentence has to reflect the seriousness of that matter. For that reason, I find that the state's recommendation is appropriate. As to count 1, I sentence you to a term of prison of 8 years in prison. Due to the Reagan-Tokes law, then there would be an additional possible 4 years that would be at the discretion of the Ohio Department of Rehabilitation in the event that that additional time is imposed. You would be entitled to a hearing. So that would be a total possible maximum of 12 years. Counsel, did I explain the Reagan-Tokes law?
Yes, Your Honor.
Appropriately?
Yes, Your Honor, for the record, we object to Reagan-Tokes, just for the record.
I understand, thank you. All right, I also order forfeiture of the Smith & Wesson 910 handgun. Then as to count 2, I order that you serve 12 months in prison and that be served concurrent with the sentence for count 1. We will give you credit for time served in the amount of 399 days. I am going to, and I guess I'll ask Mr. Flays. Mr. Flays, is the state moving at this time to dismiss the first and second specification to count 1 as well as count 3?
Yes, Your Honor, we are.
Okay. The first and second specifications to count 1 are dismissed and count 3 is dismissed. Mr. Morissette, I order you to pay the court costs in this case. If you fail to pay any financial penalty or cost, the court may order you to perform up to 40 hours a month of community service until the court is satisfied that you're in compliance with an approved payment schedule. If you perform community service on this basis, your financial penalty or cost will be reduced to the extent of the federal minimum wage. The court isn't ordering any payment plan or community service at this time, but renders judgment against you for the cost for which execution may issue. I will limit the amount taken from your inmate account while you're incarcerated to $5 a month toward that. I also want to go over your appeal rights with you. You have the right to appeal or seek leave to appeal the sentence imposed. If you're unable to pay the cost of an appeal, you have the right to an appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed at no cost to you. If you're unable to pay the cost of documents necessary to an appeal, the documents will be provided to you at no cost. You have the right to have a notice of appeal filed timely on your behalf. All right, I believe that covers everything I needed to cover. Mr. Flays, is there anything else we need to address?
Just the PRC advisement, Your Honor.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.